The preliminary ruling procedure is a cornerstone of our legal system. It promotes uniform interpretation and application of European Union law across all member states. This procedure has played a paramount role in the development of European Union law. It was used as a means of laying down the fundamental principles of EU law: direct effect, supremacy, or consistent interpretation. The Court of Justice of European Union, the CJEU, has been able to develop an autonomous pan-Union judicial order thanks to the use of this procedure. The preliminary ruling procedure is enshrined in Article 267 of the Treaty of the Functioning of the European Union and serves as a vital link between the national courts and the CJEU. It ensures that the Court of all European Union member states can request guidance on the interpretation and validity of EU law when they encounter doubts in their own proceedings. Well, this mechanism is what binds us as Union. It promotes legal certainty and consistent application of EU legal framework. The Article 267, paragraph 1 of the TFEU provides that the CJEU shall have jurisdiction to give preliminary ruling concerning a. the interpretation of the treaties, b. the validity and interpretation of acts of institutions, bodies, offices, or agencies of the Union. Paragraph 2 and 3 of the legal provisions enshrines that where such a question is raised before any court or tribunal of a member state, that court or tribunal may, if it considers that a decision on the question is necessary to enable it to give judgment, request the court to give a ruling thereon. Where any such question is raised in a case pending before a court or tribunal of a member state, against whose decision there is no judicial remedy under national law, that court or tribunal shall bring the matter before the court. What can we infer from this provision? Well, first of all, that we have two types of preliminary rulings. Well, one related to interpretation of EU law and the other to the validity of EU law. First of all, the validity reference cannot be about primary law, about treaties, about Charter of Fundamental Rights. However, both types of references can refer to soft law, like in Grimaldi, Florescu, FBF case. Even though those acts are not binding, they still have some legal effects. The reviewability of soft law measure is important then. In FBF, European Banking Authority issued the guidelines on product oversight and governance arrangements of banking retail products, which were challenged in the FBF case. The guidelines were mainly addressed to national competent authorities. The French competent authority published a notice on its website to state its compliance with the guidelines. According to the notice, the guidelines would apply to credit institution, payment institution, and e-money institutions under the supervision of the authority. The French banking lobby, FBF, challenged the notice before the Conseil d'État, requesting that it be annulled. FBF's main claim was that the guidelines on which the notice of the authority was based were ultra vires. The lack of binding effects is not as such as to preclude the court's jurisdiction under Article 267 TFEU, which, according to the court, extends to all acts of EU law without exception. A reference can be made only by a body that is considered a court or a tribunal, which is an autonomous term. So for the purposes of Article 267 TFEU, a court or tribunal has to be a body which is established by law, permanent, with a compulsory jurisdiction. Its procedure should be inter partes, it should apply rules of law, and of course it has to be independent. An inter partes hearing is one at which all parties relevant to the application being heard can be present and able to make representations to the court. Of course, not all courts and tribunals are created equal. A reference will be mandatory if that court or tribunal is one against whose decision there is no judicial remedy under national law. Moreover, no national court could declare the Act of European Union institution invalid. So any question of validity of the secondary act of the European Union should be dealt with by the Court of Justice. That was established in the Photofrost case, where an EU levy was payable on imports of binoculars into Germany originating from Denmark and United Kingdom. The levy was subject to a waiver in certain conditions, of course, but the Commission addressed to Germany a decision to the effect that it could not apply that waiver in that case. Thus, the Custom Office issued the notice for the post-clearance recovery of duty. Photofrost applied for the annulment of the notice before the Finance Court of Hamburg, which took the view that the validity of the Commission's decision was indeed doubtful. In connection with these proceedings, the Finance Court of Hamburg referred to a preliminary ruling whether a national court could review the validity of the decision adopted by the Commission and whether the relevant Commission's decision was valid. National courts do not have the power to declare EU acts invalid. Divergences between national courts as to the validity of EU acts would put in jeopardy the unity of EU legal order and legal certainty. Well, more on the intricacies of the preliminary ruling procedure will be debated on our EJTN dedicated seminar in Luxembourg. Together, we will underscore the significance of the procedure and its crucial role in maintaining the unity and integrity of EU law with practical exercises and, of course, with debates. Don't forget, as a national judge, we have the duty to work jointly with the CJEU judges to safeguard the values and the aims of the European Union, ensuring the EU legal framework remains a driving force for integration and cooperation for the benefit of our individual. Thank you.